Now, if you are a paranoid, uncommunicative type of boss who can't delegate, then you probably don't have much of a business, and probably your employees hate you too, but you get full marks in the confidentiality stakes. Despite the proliferation of electronic listening devices which could make spying on your competitors so much fun, you will probably find that your confidential information will probably be taken by your employees. Now, to protect yourself, you can put a confidentiality clause in employment agreements. But for those of you who haven't quite got round to employment agreements yet, you'll be pleased to hear that the law of confidentiality implies a duty on employees to keep their employers' secrets, just that, secret. And that duty extends beyond the time when they've left your employment. So one of the things that you can do, and a very effective thing, is to make your employees aware of this duty of confidentiality. But what is your confidential information? Well, generally there are three things that a court will consider. One, was there a quality of confidentiality about the information? For instance, the Coca-Cola formula, and maybe in your business, something which is essential to the business. For instance, the client list. Number two, was it given in circumstances which suggested that it was confidential? Now, the practice in some companies of labelling things confidential is great evidence in the law of confidentiality. However, sometimes it's taken up with relish by the entire company, who stamp everything confidential, and that somewhat devalues this protection. Another thing you can do is to have a procedure of document handling and a secure storage area. This too will be great evidence that that information was confidential. But again, this can be valued if there's a culture of non-compliance within your company. Number three, was it used to the detriment of the giver? For instance, are your employees or your ex-employees selling the same goods as you are? Or has it been handed over to your competitor? You see, not everything labelled confidential will be treated as such by the courts. So too, the courts will want to see some evidence of real loss and not just hurt pride.